Hello, everyone, and welcome back to Monday Bible, the podcast exploring the evolving relationship between law, technology, and society. Today I'm joined by Edward Cronan, one of the most respected IP litigators in the UK, lead barrister who represented Stability AI in the landmark UK copyright case against Getty Images. Ed was named Junior IP Barrister of the Year by Managing IP, described by Law 360 as an IP heavyweight, and regularly appears in the most complex IP and technology cases before the High Court, Court of Appeal, and beyond. He holds a first-class degree from Cambridge, a distinction from Oxford in IP law, and has become one of the key barristers shaping how UK courts approach AI and IP. Ed, thank you for joining me, and congratulations on this major win.
Thanks. That was an extremely flattering intro. I'm not sure I'll ever live up to that, but I'm very grateful for it.
The Getty versus Stability AI judgment has quickly become one of the most talked about decisions in the global AI copyright debate, not only because of its outcome, but because it's, I think, the first fully reasoned ruling from a major court addressing how copyright principles apply to modern Gen AI models. Stability AI has largely prevailed in the case, and what, in your view, are the key takeaways from this judgment?
Well, the main thing to keep in mind when we're looking at the liability for generative AI systems under the laws of intellectual property is that there are different phases in what it means to be a provider of a generative AI system. And you can broadly split these up into the question of inputs, which is really all about training, and outputs, which is what the system produces for its users. And then there's also a third question, which is part of what this judgment looks at, which is what about the model itself? Is it an infringement of intellectual property rights to copy the model weights or to distribute the model weights themselves? And I think there's something in the Getty case which informs us about all three of these different areas. Because, certainly at the outset, this was a really full width case, which looked at copyright infringement, trademark infringement, database right infringement, and it looked at everything right from the early development of the model all the way through to how user outputs are provided through offline model use, so users downloading the model weights and installing them on their own computer, but also on Stability AI's online portal, which is called Dream Studio, where users could go and generate images. And the case really had to traverse all those areas and look at how intellectual property rights infringements could occur in those different areas. In particular, I mean, the first one is perhaps the one which gets most of the attention, or did originally when people were first thinking about sort of generative AI IP infringement, and that's the question of inputs and the training stage. Because everyone knows that sort of model developers want big training data sets. And of course, in every case, you need different content to train different types of model. And because this was a case all about images, what was needed were obviously large numbers of images. And strangely, one of the common points between some different models which work in different media is that there's only so many places you can get a really large amount of content. And one of the answers to that, or a number of different model developers have looked to what's called the common crawl, which is this open archive of web data. And in this case, the Getty case, the party that actually went and looked at that wasn't Stability. It was a third party called Lion. Lion are a non-profit organization who created these image data sets. And interestingly, the stable diffusion model has gone through a number of iterations which were considered in this judgment. And interesting that one of the things the judge held was that actually the first versions, the version 1 models, weren't actually trained by Stability. They were trained by an independent group of computer science researchers called the CompFIS group. And in particular, a sort of now quite well-known model researcher called Robin Rombach was a big part of this. Robin then went to work for Stability, and they released a V2 of the model. And these models were trained on parts of this Lion data set. And that's how the case with Getty Images really got started, because Getty realized and came to allege that there were large numbers of their images in those data sets. And so the question became, in the UK, had there been use of those data sets to train models? And then was it as a result of the use of those data sets, the behaviour of the models came to cause infringement of Getty's IP rights? And so that's really the origin of the whole dispute. In the UK side of it, actually what happened in the end was that the training part, even though that's the origin, this is how Getty say their content, became to be used by Stability, actually fell by the wayside in the end, because it was shortly before trial Getty accepted that actually the training of the models didn't happen in the UK. And this is really all about where the compute is, where are those really big data centers, which you can use to do this really heavy model training process. And Getty finally accepted that hadn't happened in the UK. And so the sort of remaining allegations Getty wanted to pursue were really about individual development activities. It was about what developers had done in terms of data annotation or in terms of handling subsets to test model performance, and even what had researchers in the UK done in order to improve the quality of data sets, that kind of material. But in the end, it was after the oral evidence in the trial, Getty dropped that case completely and decided instead to focus just on the outputs side of the case.
So could you walk us through the legal strategies of both sides and key English law doctrines that shaped the case? We are in a multi-jurisdictional environment here, so some of the listeners may not be familiar with English law so much.
Well, interestingly, the law in the UK about IP is very closely aligned with Europe still. All of the European directives on intellectual property were adopted in the UK. So trademark infringement and copyright infringement in the UK are very, very close to the EU still. Getty's overall case, as I said, it had this input element, which was alleged to be copyright infringement and database right infringement. And then the outputs case, which was said to be copyright infringement, trademark infringement. There was a UK doctrine called passing off, which ultimately really just came to the same sort of conclusions as trademark infringement, as Getty argued it. And those were the key parts, aside from this other aspect called secondary infringement, which is dealing with the sort of finally produced model. In terms of the bits that really came through and the judge had to deal with at trial, I think the most interesting bit is this bit about the trademark infringement by outputs. And Getty's case on this was very similar to Getty's case on copyright infringement in many ways, or copyright infringement on outputs, which is all about saying that when users use the model in a certain way, they're going to get a result out of the model, which is an infringement of Getty's intellectual property. And that's quite hard to understand at first, but really it all comes down on the experts. This is how the experts explained it in the case. I should say we had two really talented computer science experts. On Stability's side, it was a Professor Thomas Brox, who I think is from KU Leuven. And then on the other side, we had Professor Hani Farid. And what these two experts agreed on was actually a lot of the technical background. And the most important bit of technical background when it comes to understanding why you might have an IP claim against the output of a model is this idea of memorisation. Mm-hmm. And what the experts agreed on, and there's an interesting passage on this in the judgment, actually, in the secondary infringement context, is it's all about the way that models learn patterns. And so you want the models to learn certain patterns. You want it to be able to produce a picture of a cat or a dog if you put in those prompts. But sometimes instead of learning that sort of general pattern, it learns an overly specific one. And often this is called overfitting. Overfitting is where instead of learning a sort of an accurate probability distribution, that the model's something's gone a bit wrong. And what's happened is the model has over specialized on its training data. So in this case, and in a lot of other models, what the model training process involves is getting the model to essentially guess what the user's looking for, and then showing it the real image, and then saying to the model, well, how far off were you? And then using that to teach the model really what the user's after. But of course, if you have too many of one image in there, the model doesn't learn the general sense. It just says, well, I know every time that people want this identical image. And so it learns a sort of fixed pattern instead of learning the general statistics of a sort of natural set of images.
Mm-hmm.
And the result of this is it Getty's allegation, in this case in the copyright infringement sense, that the model, if you gave it certain prompts, would reproduce a whole Getty Images photo. It sounds like a really remarkable suggestion. And in the end, Getty didn't pursue those allegations all the way to the end of trial. But what they did pursue was an allegation that the model would produce a Getty Images watermark. And so the explanation for this is that if there have been images featuring something like a watermark in the training data, then the model learns that this is something which people might want on their images, just to use colloquial language. It becomes part of the model's probability distribution.
Mm-hmm.
And as a result, there was this claim that there were outputs from the models with watermarks on. That was able to succeed where the claim on copyright infringement was dropped. One of the reasons this is really interesting is because there's big differences between how different AI lawsuits are trying to prove these kinds of outputs infringement issues. And the way Getty decided to do it in this case, on both the copyright and the trademark angle, was using what you might call an adversarial attack, if you're a computer scientist, which is to try and provoke the model into outputting something sort of essentially unnaturally, getting the model to spill out some of its training data.
Okay.
And the methodology that Getty used seems to have been inspired by a paper by Carlini and a group of other researchers, and they looked at memorization of material by diffusion models. And what they showed was that the images that were most duplicated in the training data set, because the Lion data set is an open data set, they looked and they said, what are the most reproduced images, most duplicated images? Because we think that overfitting is going to happen relative to those images. The model, instead of learning the general statistics, is going to memorize exactly what that image looks like. And so what the researchers in that paper did was they took the prompts to sort of generate these images as the caption which the image was associated with in the training data set. So the whole caption, however long it was, if you give that verbatim to the model, will it give you back a copy of the image that was in the training data? And so they found some quite close matches in that paper. In particular, there's one on the front page for a lady called Anne Graham Lotz, and she's not a big internet celebrity or anything like that. And there's this one image of her on the front of the paper, which is like a superbly close reproduction of what she looks like. And so Getty were inspired by this to try this technique, and they put in a huge number of Getty captions from their website as prompts and tried to produce images which they said were copyright infringing, or they used them to try and prompt the model to produce outputs which had watermarks on. And so this is one way that you can try and get the evidence to prove this kind of case. It's quite challenging because for every prompt, you don't get the same output every time. In Stability's system, there's sort of 4.3 billion different starting values the model can take, these noise patterns from which the model develops an image. And so not only do you have to sort of prove that the model will output the image you say it will, but you've got to say, well, is it actually going to happen in the real world? And what Stability said was that this kind of adversarial attack that Getty did was contrived. That was a big part of Stability's arguments at the trial, to say, well, no normal user is ever going to do this. And if you have to do it 10,000 times, you have to put in a 70 or 100 word Getty prompt in order to get an output like this, then what relevance does this have? And that was one of the obstacles facing Getty on that case. And then in contrast, the judge found that in fact some of the much simpler prompts which Getty used might be relevant. So she looked at prompts which included the word news photo or the words vector art. And she found that these could lead to watermarks appearing on output content for certain of the models. And she held that that those kind of prompts were realistic prompts that users might actually use. So she rejected the long adversarial attack type prompts and said, well, actually, what might users use? And that's quite interesting when you look at the recent Gemma decision, the OpenAI
Yeah.
decision, I think, is it in Munich?
Yeah, but let's discuss it a bit later. You were a litigator in this case, defending one of the parties, so you cannot reveal everything of the case. But are there any elements of the reasoning that surprised you?
I think, and this is a sign of a really dutiful judge, is that the judge has been through all the parties' evidence, and it's a meticulous judgment. It's 200 pages long, and just setting aside the fact that I act for one of the parties, it's fantastic to have judges who are willing to grapple with this kind of material, the amount of the depth that you have to get into, computer science, expert evidence, etc. I think it's a real credit to the English legal system that it can produce this kind of helpful judgment, which includes consideration of all the issues that the parties have raised. I think one of the problems which with the online commentators get a bit wrong is they say, well, the judge didn't consider this point or that point, and you say, well, nobody asked the judge to consider that point. It's it's a judgment between the two parties, and that's how the English legal system works. It's how most legal systems work. It is that the two parties between them ask the judge to adjudicate on the issues which are relevant to their commercial dispute. And one of the things which I know some people have said, have commented on, is the fact that the judge dealt with the secondary infringement allegations on the basis that the model didn't include copies of any Getty Images. And some people have said, well, how did she come to that conclusion? But the answer is, that was the basis on which the case was argued by Getty. Now, why they argued on that basis, you might infer that it was because they couldn't prove that there were memorization of any of their images. But that's part of Getty's case. And so when people say, oh, I'm surprised the judge just dealt with it on that basis, that was the only basis she was ever going to be able to deal with it on, because that was the case she was being asked to adjudicate upon.
Some of my colleagues who are IP and AI experts stated that the court placed substantial weight on the technical nature of model weights, including the fact that stable diffusion is 5 times smaller than the training corpus. Do you think it's relevant? And does it sound like something to rely on in copyright testing?
Yeah, I mean, I think it's a really simple fact that's a really effective proof that in fact models can't memorize all their training data, because it's simply not possible. And there's actually quite an interesting paper by an author called Marullo, and it's looking at essentially what can you tell which bit of the model weights might include memorized information. And this goes back to what we were talking about earlier when we talk about overfitting and how the model sometimes over optimizes on particular bits of training data. And what the authors of this paper said is it's interesting. We can look at some of these statistics in the model weights, and actually certain types of reasoning in language models, they say, are associated with memorization like properties. Like, for example, the ability to do arithmetic is a sort of memorization like property. And so it's clear that most of the model weights are being used for generalization, but maybe some small amount can be used for more memorization-like tasks. And in the context of a language model, that could be for memorization of facts or memorization of sort of simple rules, which I don't think anyone's going to object to. However, on the other hand, if you have memorization of copyright material, then you can have a problem. But the overall scale of the models indicates that they're achieving an extraordinary level of compression. So they simply can't be memorizing everything. And the interesting thing from a copyright point of view is that models most efficiently learn things when a large number of training samples agree with each other. And this is something both the experts said in the stability case. He said, well, if something is present across a large number of images, you're learning the common characteristics in the case of an image model, it's pretty unlikely that that's going to reflect copyrighted content, because under EU law, the test is that the author's own original intellectual creativity. And so it's almost the opposite of what copyright is looking to protect. The model's taking the common things to all the images, not the unique intellectual things which belong to any particular author. So if the models are operating well, if they're trained well, the data sets are set up properly, it's quite challenging to end up with memorized content. Now, there are obviously exceptions to this. And I think the Gemma decision is an interesting one about song lyrics, because, of course, song lyrics always turn up exactly the same. So if you have lots of people talking about song lyrics on the internet, then that might make it into the training data. And you don't want song lyrics to change every time you ask for them. You want them to always be the same. So there are some interesting sort of edge cases there where you might be more likely to get memorization.
This is what I wanted to ask. The judgment avoided deciding whether training inside the UK would itself be infringing because of the case and the arguments parties submitted, but strongly implied that the result is not a copy, even if the process involves reproductions. And the Munich Gemma judgment adopts the opposite approach, that training memorization can be a reproduction even without identifiable stored copies. What's your position about it?
I think the two judgments aren't directly in conflict there, because in the secondary infringement judgment in the UK, as I said, Getty didn't contend that the model contained copies of any of their images. So that question of whether there was memorized copyright information in the copyright protected material in the model didn't come up. Now, in the question of whether a particular training activity constitutes copying, again, the judge didn't have to consider it in the UK case because Getty pulled their claim on it. There are obviously some acts which do involve literally, you're transferring a set of images from one hard drive to another, that would ordinarily be seen as an act of copying. I think one of the more interesting questions, which everyone at the moment is very much focused on looking at the exceptions and overall exceptions for liability. But I think one question which is going to become increasingly important is, well, take an example of a sort of large language model, which you've trained on all kinds of different text data. And let's say that you are the owner of a particular book, and that's been copied in the process of training the model. Well, certainly in the UK, we don't have this idea of statutory damages like you do in some jurisdictions. The question of the value of the infringement, the damages, is assessed on a reasonable royalty basis. So the court asks, well, what number would be reached in a negotiation between the parties before the act took place if they were looking to negotiate a number? And one of the problems, again, with sort of these models is that when you're feeding the model in, hundreds of thousands of millions and millions of tokens of text, you're not particularly interested in the copyright protected content. What you want is the associations between semantic structures and grammar, the meanings of words, combinations of words as a general rule. And for that purpose, one book is much the same as another. Whereas for an individual reader, obviously there's a big difference between a work by, Nabokov and a Tom Hardy, or, these are very different end goals. But for the purpose of a large language model provider, one of the things which no doubt they'll be saying if they're on the hook for any kind of damages in a jurisdiction like the UK is there's no marginal benefit to me of this particular copyright work, because it's just a matter of convenience. I could go and I could take another copyright work or another out of copyright work, and it doesn't make any difference to the functionality of my model whether I have this particular 1,000 tokens of text or another 1,000 tokens of text. So why would I pay any more than a kind of trivial amount for any individual piece of content? That could become quite an interesting argument down the line when people sort of start talking about what amounts should be paid in licensing discussions. And that's interesting in part because there's a big contrast between the case where you're training a generalist model and you just want it to have, for example, an understanding of English grammar, and when you're training a very specialist model. Say, for example, you want a model that's going to give people advice about legal problems or advice about physiotherapy, and then you say, well, where am I going to get the content to train a model to do that? And then suddenly you're talking about specialist content, and then you're providing it to somebody who's training a model to compete with the people from whom the content has come. and then your kind of notional negotiation between a sort of a licensee and licensor, which is how UK damages are generally assessed, would probably be a different one. You might say, well, in that case, the model provider really needs this particular specialist content in a different way from the way it simply needs some content from which the model can learn English language and grammar.
So coming back to this differences between UK decision and the Munich decision, is it the difference between the legal systems or approach or concept of AI training, copyright between the systems, the courts? What's your position on that?
Well, as I understand the decision, the main difference on the outputs was that the Munich court had what you'd call a non-adversarial attack, where it just said, okay, give me the song lyrics, and you could show that the model in fact would then just hand over the song lyrics. And I really respect the lawyers who came up with that, because it's very neat, it's very clean, it's the kind of thing a normal user might do. So that's a really nice proof of concept. I think once you've proven that the model can output a copyright protected work, it's very hard to resist an argument that the model contains a copy of the copyright protected work in some form. Just a matter of inference. You can't identify the particular weights, but it's very hard to say that it doesn't. And now that's very different from how the UK case was argued by Getty, because Getty said, we're not going to try and convince the judge that the model includes any copies, and we're not going to try and convince the judge anymore, although they did originally, that the model could output a Getty copyright protected work. So their argument on the secondary infringement side was a different one, which is that there's copyright infringement when the model is trained, which could be years ago in a different country, and the UK law on copyright will nonetheless stop you from dealing in that model in the UK years later. That was quite a special argument, a specialist argument as well, in that it's quite niche. It would be quite consequential. It is one of the things commentators noted, because that Getty argument would apply to essentially any model trained anywhere in the world. Yeah. And you could bring a case in the UK and essentially push a big legal fight about how the model was trained, even though it wasn't trained in the UK, and try and get it taken off the UK market. So that's quite consequential for UK users, UK consumers.
I wonder if there are any other so relevant cases in the UK or Commonwealth world. Should we expect more litigation in the UK, or is there any legislative reform awaiting us? What do you think about it, about the future of AI development and copyright law?
I think that from a lawyer's perspective, the really interesting thing at the moment is that there's going to be a lot of different cases where different lawyers try different ways of proving these cases. And for example, there's an ongoing case in, I think it's New York, where I think is it the New York Times is suing OpenAI, and they've just obtained an order for disclosure of 20 million user chat logs.
That's interesting.
And that's really interesting, because we've talked a bit about how the Gemma case, there was a non-adversarial attack. In the stability case, there was this adversarial attack where they tried to provoke the model into generating copyright protected outputs. In that case in New York, they've gone a different approach, and they've said, we're not doing a proof of concept, or not in this area of the case. What we're going to do is we're going to get real user outputs, and then we're going to compare those to our own copyright works. And so that's a really direct approach, which sounds like a really big and expensive approach, 20 million user chat logs. And then you've got a big computational question, which is, how do you compare 20 million user chat logs against the number of copyright works being asserted, which, presumably is a very large number. And so you then actually have a kind of big data computing job to do, where you have to compare a huge number of copyright works against these outputs. And for text similarity, well, it must be doable. It must be why they're asking for it. But for example, in the Getty case, they decided not to push for that kind of disclosure, perhaps because there was no way that they could think of for doing a comparison of their database of copyright works against user outputs. And so Getty never even tried that avenue in this case. But it may be that if the what they call the plaintiffs in that US case can come up with a really good way of checking those user output logs for potential copyright infringement, then that could become a more common approach, which avoids some of these sort of issues with experimental analysis that we had in the UK case. So I think that's one interesting area, is how's the practice of these cases going to develop.
How do you foresee the law itself? Have we achieved equilibrium, or is it going to be changed somehow, amended? Should we expect some fragmentation? Because it seems that the UK, you said that it's quite similar to EU law, but we have this TDM exception and all these discussions whether it's applicable to all the ways of training of AI. Now the discussion after the Munich case has become even more lively. What do you think about UK's law?
I think that everyone needs to just take a breath
Okay.
and wait and see, because there's been a lot of different new topics over the years, and people say, oh, we need a new regime for legal liability, we need a new way of dealing with this, and quite often the urge is to put in place legislative intervention. At the moment, I think a lot of people think this seems extremely urgent because AI is appearing everywhere. I'm more on the side of let's actually wait and see what happens.
Okay.
Everyone's in a bit of an AI honeymoon phase at the moment. Who knows which of these AI development companies are going to be big successes and which are going to spend far too much money on data centers and and eventually go bust. And I think what we'll see is that in fact the profitable AI businesses will be those which really help their customers do useful things. There'll be a lot of AI generated slop online. I don't think that's going to be a major goal for sort of legislative intervention. I think a lot of the existing laws you can see that are already having some effect. I don't know if you saw the other week, there was some intervention. I think it was Bryan Cranston, who was the main actor in Breaking Bad, who sort of called on one of the model providers in the US to change how they were producing his likeness in output content. And so I think there's going to be a degree of pressure from just real world and PR concerns. There's going to be pressure by the existing laws, and that'll affect how companies behave, and everything will start to sort of settle down a bit, and there'll be a bit more of an understanding about what society agrees AI model providers should or shouldn't be doing. The legal cases under the existing laws will continue through the systems, and we'll start to get an understanding of what kind of liability they impose. And we'll see more commercial deal making between traditional rights holders and businesses in generative AI. And I think we could see a lot of very happy relationships there, to be honest, because most of these generative AI businesses aren't straight competitors. Even in this case, obviously Getty and Stability have fallen out enough to go to a very expensive court case. But I don't think that anyone has ever believed that BBC News is going to illustrate a recent news article with an AI generated image. I mean, it's just not how the world works. And so I'm hopeful that there'll be lots of room for both the legacy rights holders and for exciting new AI companies. And I'm not sure that we need to rush into imposing new legislation to bring balance to that. But I understand, particularly for people in the creative industries who are struggling. I have a lot of sympathy for that. That's probably the one area where I do wonder whether something needs done. But at the kind of bigger picture level of big rights holders who can do big licensing deals, I'm not too concerned about their future right now.
I fully agree. I would also wait and see. However, in the EU, we are now awaiting the discussion whether the EU AI Act will be reformed or put on hold somehow. This month it should be revealed some news about it. Thank you so much for this conversation. Your insights from inside one of the most important AI cases so far, and your perspective on the broader legal landscape. Incredibly valuable. Thank you for being with us.
Yeah, thanks so much for inviting me on. It's lovely to discuss the case. It's been such a big part of my life for the last year or so.
So maybe one last word. How many hours have you spent on the case? Maybe you can tell us. Is it a few hundreds, few thousands?
Yeah, it was certainly enough that I don't think I accepted any new work in about the first half of this year because the trial was so enormous. In fact, the trial was so big that it almost made me reschedule my wedding because I got married about 4 days after the trial ended. And it looked at one point like the trial might go on for so long that I was going to have to tell my fiance that we were going to have to move the wedding. But thankfully we finished it in time. But it's certainly kept me very busy.
Big congratulations for your wedding and for the case. And thank you for being with us. And to our listeners, you will find the links to the judgment and papers as mentioned in the links. And if you enjoyed this episode, subscribe, leave a review, share Monday Bagel with your colleagues, especially those working at the intersection of law and AI and emerging technologies and IP. Thank you and bye-bye.